16. Mention the constitutional provisions to safeguard and ensure the independent and impartial functioning of the UPSC. Further, assess the limitations of UPSC in effectively performing its role as the watchdog of merit system in India as envisioned by the Constitution. Approach, very briefly introduce the objectives of creating UPSC. Then mention the constitutional provisions to ensure its independence and impartial functioning as a watchdog of the merit system. Discuss the limitations of UPSC in performing its role. Conclude appropriately. Answer. UPSC was created as the central recruiting agency with constitutional status to safeguard its independent and impartial functioning as the watchdog of merit system in India. It also renders advice on service matters and is consulted by the government in deciding disciplinary matters. Therefore, it is necessary to ensure its impartial and independent functioning to ensure meritocracy in services. Constitutional provisions for independent and impartial functioning of UPSC. Security of tenure. Its members and chairman can be removed only by the President, only on the specified grounds and only through specified procedure. Service conditions. It is fixed by the President and can't be varied to their disadvantage after appointment. Charged expenditure, salary, pension, allowances, etc. of the members and chairman are charged on the consolidated fund, therefore not subject to the annual voting. Check on appointments. Chairman is not eligible for further employment in COI or estate. A member of UPSC is eligible for appointment as the chairman of UPSC or Estate Public Service Commission (SPSC), but not for any other employment in a COI or estate. Chairman and members are ineligible for a second term. Annual report on performance to President, who places it before both houses of Parliament along with a memorandum explaining the cases where the advice of the Commission was not accepted. All cases of non-acceptance are approved by the Appointments Committee of the Union Cabinet. An individual ministry or department has no power to reject the advice of the UPSC. The President, in respect to all India services and central services and posts, may make regulations specifying the matters in which it shall not be necessary for UPSC to be consulted. All such regulations shall be laid before each House of Parliament, which can amend or repeal them. Limitations. UPSC is merely an advisory body whose recommendations are not binding on the government. It has no say in appointment of members and chairmen of tribunals and commissions. It is not consulted while appointing personnel to the post of highest diplomat and temporary jobs. The President can exclude posts, services, and matters from the purview of the UPSC. A role of UPSC in disciplinary matters has been affected by the emergence of CBSE because the government has come to consult the anti-corruption watchdog as specialized agency. It is not consulted while making provisions for any kind of reservation. UPSC is a constitutional body and its advice should be given primacy when other agencies, like CBSE, are also giving their advice. The government shall submit action taken report before the Parliament in a time-bound manner stating the reasons for not accepting its recommendations. Realizing the ideals of good governance depends on the effectiveness of the civil services, which in turn depends on the effective functioning of the recruiting agency. Hence, there should be any compromise in the independent functioning of the UPSC. 17. What are the key issues in the context of electoral funding in India? How far do you think the idea of state funding of elections can address these issues? Approach. Mention the important issues regarding funding of elections in India. Briefly explain what you understand by state funding of elections. Critically analyze if state funding of elections can address the issues. State way forward. Answer. Electoral funding implies financing the electoral process of political parties and candidates. Just like any other activity, it requires financial resources. But in India, it is marked by the following issues. Political parties receive majority of their funds through anonymous donations, approximately 70% through cash. Despite provisions under Section 29 of RPA 1951, parties do not submit their annual audit reports to the Election Commission. Parties are exempted from income tax, which provides a channel for black money hoarders. Political corporate nexus remains intact despite creation of electoral trusts as corporate houses namely fund them. Further, amendments to FCRA allow foreign funding in elections. which can lead to eventual interference in governance. CIC in 2013 stated that political parties come under the ambit of RTI Act. However, parties have defied it. Due to increasing role of money power in politics, the EC sought insertion of a new section, 58B, to RTA 1951 to enable it to take action if parties bribe voters of a constituency, which has not come to light. State funding of elections, when the government gives funds to parties or candidates for contesting elections, has been deemed as one of the ways of curbing the influence of money power. In India, current state funding measures include security, office space, exemption from income tax, etc. given to national parties. Arguments for state funding of elections. Committees like Indrajit Gupta Committee on State Funding of Elections 1998 Law Commission Report on Reform of the Electoral Laws 1999 Sekadar 2005 have recommended partial state funding of elections. It will check quid pro quo and can help curb corruption, thereby reducing politician corporate nexus and criminalization of politics. It will provide a level playing field for those candidates who are not backed by major parties or powerful individuals. Arguments against state funding of elections. As per National Commission to Review the Working of the Constitution 2001, a stringent regulatory framework needs to be established before initiating state funding. State way forward. The Election Commission does not support state funding of elections. Instead, it seeks radical reforms regarding spending by political parties. The government is already grappling with budget deficits. Thus, state funding places unnecessary burden on the public exchequer. Further, the allocated amount can be spent on welfare activities instead. It might encourage non-serious individuals to enter the political domain merely to avail funds. There is a high possibility that state funding will be used as a supplement and not as a substitute of candidates' own expenditure. Way forward, steps in this direction should be taken only after assessing the economic impacts of state funding. It also should not constrain government's welfare activities. Further, it needs to be accompanied by strict accounting and transparency. Self-regulation by political parties, longer campaign period in elections, as well as strict implementation of existing rules can go a long way in addressing the concerns pertaining to electoral funding within the country. 18. Separation of powers. In case of India has acquired its own uniqueness under the constitutional arrangement. Explain. Approach. Briefly explain the concept of separation of powers. Mention the constitutional provisions that reflect separation of powers. Explain if complete separation is practiced in the Indian context. State judicial pronouncements regarding separation of powers. Answer. Generally, there are two commonly followed models of separation of powers between organs of state. One follows Montesquieu's dictum providing for rigid separation of powers. Other is Westminster model providing for looser separation and is based on the principle of the supremacy of Parliament. Indian Constitution, however, has provided for a unique separation of power. Thus, it provides for a third model of separation of power. In India, separation of powers has been laid in the Constitution under the following provisions. Article 50, which states that the state shall take steps to separate the judiciary from the executive, to ensure independence of the judiciary. As per Articles 122 and 212, validity of proceedings with the Parliament and state legislatures respectively cannot be called into question in any court, thus ensuring immunity of the members from judicial intervention. According to Articles 121 and 211, judicial conduct of the judges of the Supreme Court and High Courts respectively cannot be discussed in the Parliament and state legislatures. As per Article 361, the President or Governors are not answerable to any court for the exercise and performance of their official duties. Here, the Constitution recognizes the organs of state, but it does not expressly vest the different kinds of power in different organs. There is functional overlap in India, which is reflected through the following. Under the Indian parliamentary system, members of political executive are part of the legislature too. The legislature exercises judicial powers in case of breach of its privilege, impeachment of the president, and removal of judges. The executive exercises legislature's lawmaking power under delegated legislation and also while passing ordinances. Tribunals and other quasi-judicial bodies that are a part of the executive discharge judicial functions and mostly have a member of the judiciary. Briefly explain the concept of separation of powers. Mention the constitutional provisions that reflect separation of powers. The power of deciding the number of judges as well as appointing them is given to the President. Under the power of judicial review, judiciary can give directions to executive in constitutional and statutory measures. Thus, the system of checks and balances is also prevalent to prevent arbitrary use of power by one organ. Further, the Supreme Court has reiterated the importance of separation of powers in several judicial pronouncements. In the Kearse-Vinanda Naradi case 1973 it stated that the doctrine of separation of powers is an integral part of the basic features of our Constitution. The Supreme Court also rejected the National Judicial Appointments Commission Bill 2014, terming it unconstitutional and deemed it a threat to the independence of judiciary. Thus, in India, system of separation of powers has acquired its own uniqueness with sufficient checks and balances to ensure that no organ of the government exercises arbitrary power. 19. Highlight the extent of President's powers under Article 352. Comment on the judicial scrutiny of proclamation and the exercise of executive powers under national emergency. How is this power different from the one bestowed under Article 356? Approach. Stating the mandate of Article 352, highlight the President's power under 352. State a role of judicial scrutiny and exercise of executive powers when national emergency comes in operation. Mention the differences in the nature of powers between Article 352 and 356 on various parameters. Answer. Part XVII of the Constitution outlines the procedure in which the normal federal constitution can be adapted to abnormal situations effectively and confers extraordinary powers upon the Union. These emergency provisions help in guarding the democracy against the forces of disintegration, thus safeguarding the sovereignty, integrity, and security of the country. Extent of President's powers under Article 352. President can declare a national emergency if he/she is satisfied that a grave emergency exists whereby the security of India or a part of it is threatened by war or external aggression or armed rebellion. When doing so, President has following powers. President can issue directions to the states as to the manner in which the executive power of the states is to be exercised. In the event of military conflict, the President is also authorized to suspend Article 19. He can also restrict the enforcement of all fundamental rights except for Article 20 and 21. However, the President cannot act unilaterally. Such a proclamation can be declared only on the written advice of the Cabinet, subject to the approval by both the Houses of Parliament. Judicial scrutiny of proclamation. Earlier, President's satisfaction amounted to subjective satisfaction, which could not be challenged in a court of law under any circumstances. But Supreme Court in the Minerva Mills case held that there is no bar to judicial review of the validity of a proclamation of emergency issued by the President under Article 352(1). Constitutionality of proclamation can be questioned in the court of law on the grounds of malafide intention. However, court's power is limited only to examining whether the limitations confirmed by the Constitution have been observed or not. Court cannot go further into question of correctness of the facts and circumstances on which the satisfaction of the government is based. The exercise of executive powers during the operation of a proclamation of emergency. The executive power of the Union extends to directing any state regarding the manner in which its executive power is to be exercised. Unlike normal times, when Center can only issue directions on certain specified matters, during the emergency, Center becomes entitled to give executive directions to a state on any matter. Thus, the distribution of powers stands suspended and state governments are brought under the effective control of the central government. Difference in the nature of powers between Article 352 and Article 356. Parameter. Article 352. Article 356. Effect on legislative and executive functions. State legislature and the state executive continue to function. Center gets concurrent powers of legislation and administration in state matters. State executive is dismissed and state legislature is either suspended or dissolved. President administers the state through the governor and Parliament makes laws for the state. Center-state relationship. Nature of relationship of all the states changes with respect to the center. Relationship of only one state changes with the center. Lawmaking powers. Only Parliament can make laws on the subjects enumerated in the state list. Parliament can delegate the law-making power to President or any other authority. Effect on fundamental rights. It affects fundamental rights. It does not affect fundamental rights. 20. Fiscal transfers from the center to states are critical in India. In this context, explain the rationale of both general and specific purpose fiscal transfers. Also highlight the problems witnessed in the design and implementation of specific purpose transfers. Approach. Broadly discuss the horizontal and vertical fiscal imbalances arising from the assignment of tax powers and expenditure responsibilities in the Constitution. Highlight the need for resolving these fiscal imbalances through fiscal transfers. Discuss the rationale behind general and specific purpose fiscal transfers. Enumerate the design and implementation issues of specific purpose transfers and suggest a few ways forward in the concluding part. Answer. In India, there is a mismatch between revenue capacity and expenditure need of state governments. The central government has access to most broad-based taxes for income tax, corporate tax, etc., and state governments have responsibilities to provide most of economic and social services for health, education, etc., but inadequate revenue handles to provide them. Besides, variations in the size of the tax base create wide differences among the states in terms of their capacity to raise revenues. Some states also face the issue of high unit cost of providing public services for hilly states. Consequently, there are variations in the standards of public services delivered. To resolve such fiscal imbalances, a system of intergovernmental transfers from the center to the states is put in place. These transfers can take the form of general purpose unconditional or specific purpose transfers. General purpose transfers. The rationale for general purpose transfers is to enable all the states to provide comparable levels of public services at comparable tax rates. Since the emphasis is on enabling the states, the transfers are supposed to be unconditional. Specific purpose transfers. These focuses on ensuring minimum standards of services. Thus, these transfers are conditional in nature and seek to equalize the expenditure levels of the states to achieve the minimum standards in respect of specified services. The specific purpose transfers face several shortcomings in terms of design and implementation. Multiplicity of schemes. There are too many schemes, and within each scheme, there are many sub-schemes with different objectives to be financed. As a result, there is thin spread of resources with hardly any impact on service levels. No link between service levels and transfers. These tend to be incremental and are not linked to service level outcomes. Thus, the transfers are not designed to achieve the basic purpose of ensuring minimum standards of services. Uniform matching ratio. The uniform matching ratio across states makes it difficult for the low-income states to utilize the grants allocated to them fully. For example, Kerala, one of the most advanced states in education, also avails the grant by making the same matching contribution, while Bihar, which is educationally the most backward state, does not get adequate grants as it finds hard to contribute the same matching ratio. Mismatch between approved and granted funds. There is considerable difference between the approved allocation and actual grants given. This creates uncertainty in implementing schemes, inefficiency, and micromanagement. The requirement to seek grants under several different interventions within a scheme results in lack of flexibility to the recipient in the use of funds, micromanagement, proliferation of bureaucracy, and inefficiency. Thus, the 14th Finance Commission has recommended that the number of transfers should be minimized and the design and implementation mechanism for each scheme should be decided by a committee comprising of union and state government representatives and domain experts.